The next subject under the retirement plan arena that we wanted to talk a little bit about is significant changes to what's referred to as Schedule C that's attached to the annual report, the 5500 form that qualified plans have to provide to the government each year. Larger plans, by larger I mean have to file a Schedule C. Even smaller plans have to file a 5500, but only larger plans with 100 participants or more have to file also the Schedule C to that. And when we're talking about a 401k plan, they count participants by reference to the number of people who are eligible to participate. So even if you have say 120 employees, of whom maybe 80 actually participate and choose to make salary deferrals into the plan, but all 120 are eligible to do so, you have a large plan as far as this goes, and would be filing the larger, the full-blown annual report, the full-blown 5500, including all schedules that would apply, including Schedule C. And that particular schedule is worth talking about a little bit here because it was significantly changed for the year 2009, which means it's the form that's filed for this year. If your plan is a calendar year plan, the due date would be the end of July 31st of 2010, because these 5500 forms, their due date is the end of the 7th month following the end of your plan year. So if your plan year is something other than December 31st, then it wouldn't be the end of July. But if your plan year is December 31, then July 31st of 2010 is when you file your 2009 Form 5500. So the Schedule C attached to that form, if you're, again, the large employer category, you'll now for the first time be asked to provide more information than ever before about the amounts of money that are being paid to providers of services to your plan. And that there's a little bit of a disconnect right now in the sense that the 5500 form, Schedule C, requires the plan sponsors, the plan administrators to add this additional information, not just about what direct compensation is being paid out of the plan to a plan sponsor, to a plan service provider, excuse me, like a record keeper or a trustee, but also any indirect compensation. And indirect compensation, for those of you that have worked in the 401k plan field a little while, you maybe have a sense of what I mean by indirect compensation. It's very common in the 401k plan world to have what's referred to as revenue sharing, where the investments, particularly mutual funds inside the plan, may pay some money, kind of backdoor money, to record keepers. And the plan sponsor, the employer, often doesn't even know about that amount of money. You know, they know what they're paying out of pocket. They know what direct charges that the plan may be writing a check for out of the plan assets, but any additional money that may be charged out of the general fees that the mutual funds charge themselves and then paid back to your plan provider, service provider, such as a record keeper or trustee, you wouldn't necessarily, and as an employer or a plan sponsor, you wouldn't necessarily even know about that unless you asked about it. And that's where, that's what I really want to talk about here, because if you're going to, for two reasons. Number one, as a plan sponsor, you have fiduciary obligations in terms of oversight of your plan. And in fact, it's been long the case under the Department of Labor, the Department of Labor position, that any plan fiduciary, in terms of choosing who you're going to use as a service provider, who you're going to use as a record keeper, and so forth, you have an obligation really in terms of just carrying out your fiduciary responsibility to find out what fees, what compensation they're getting for the services they provide, even if it's not compensation that you're paying directly. You have a fiduciary obligation to find out what kind of compensation they're getting indirectly. And so that has not been changed at all. The Department of Labor has long held that position, but they haven't had any kind of real ways to enforce that. Well, now the Schedule C, you have an obligation to report it, but there's still a bit of a disconnect because the service providers themselves, right now, as I stand here, don't have an official legal obligation to provide that kind of detailed information to you as far as what they're getting paid on the side. That is going to change pretty soon, I'm sure. But right now, so how does a plan sponsor, plan administrator, in filling out that Schedule C, get the information if they don't have to give it to you? Well, you can ask them, and the Department of Labor wants you to ask them. If you're a 401k plan sponsor, you're an employer, the Department of Labor really wants you to be asking anyone who provides services to your plan, like ask, your record keeper, for example, ask them, basically say, to fill out this Schedule C properly, if you're a larger plan, and even if you're not, they want you to do it anyway. Ask your service providers what kind of compensation are they getting? Are they getting some revenue sharing on the side from mutual funds? And if they're getting it, it's not necessarily a bad thing. It's not illegal to get that. They just have to disclose it to you so you know overall, and you may be surprised sometimes how much money they may be making there. Some plans that are marketed as no-cost plans, the employer doesn't have to pay anything for them. Well, people don't perform services for free. I mean, they're getting compensation for that service from somewhere. And many times it may be more than the plan sponsor may be aware of. So as long as you're aware of it, then you can be in a position to maybe negotiate a different deal down the road, or maybe even some sharing of that compensation, having that come back into the plan, for example. Yeah.
I'll say, when you ask the question, make sure you ask it in writing, an email or a letter, and then document and get it back in writing, whatever the response is, so that you've built a record for fiduciary liability purposes.
Absolutely. And part of the message here too is to ask relatively early. In other words, like right now, in April or maybe May, the latest, be asking in writing from your service providers what their compensation is, not just direct, which you really should know about already, but also this more important indirect compensation, because of the fact that it can take a little while for them to provide that information to you, and with the deadline for the filing of the Schedule C in the 5500 July 31st, if you wait too late in the process, you may not be giving them enough time to respond. So you should be asking your plan providers now what kind of compensation they're getting. And another important point about this Schedule C is there's now a part of this expansion of the Schedule C, there's now information, a line on there to have the plan administrator report any service provider that refuses to cooperate and provide you with an answer to your question as to what kind of compensation they're getting indirectly from the plan, relating to your plan. So if you were to ask a service provider, with giving them plenty of time to do so, you ask them in April or May what compensation they're getting, so you can make sure the Schedule C is completed properly, and they refuse to respond in time by the end of July when your return is done, then the Department of Labor is asking you to report them, so to speak. You put their name and employer identification number and address on the Schedule C as being uncooperative. And then the Department of Labor will presumably take it from there and maybe investigate them. So there's a little bit of a hammer, potential hammer there, encouragement right now.